project during the semester, and at some point toward the final weeks, you come and discuss it. Now let's wait a little more because these conversations of ours are going to be videotaped. I've instructed them to focus the camera on me simply so that no one is involuntarily identified. And the videotapes will be placed on the course website a few days after each of our sessions. So we have another 5 minutes before we start. I'll be right back.
Sure, I'm listening on Heather. I'm undecided. So the vibe so far seems like it might be a good one to do for 1 hour, especially because I don't think that we should word of it. Yeah. No, I did an exam class last spring. It was such a mistake. Like, it was an interesting class. It was fun, but it was like I was like, why did I do this to myself when it was final exam period?
Just checking the wait list and such.
Yeah. What section are you in?
I'm in section 4.
Oh. I have no idea who your friends are.
Don't worry.
Yeah.
It's fine.
Code was actually
Okay, that's fine. I don't know. Also, you're being recorded right now.
So let me begin by suggesting to you my initial conception of the agenda of the seminar. And the aim is to bring into connection two large themes. The first theme is the present established practice of legal thought, of legal analysis, of reasoning about law, as it is established in the world, and especially established in the major countries of the rich North Atlantic world, and from there disseminated throughout the world. The second subject is the dictatorship of no alternatives that exists in the world. The world is restless under the yoke of this dictatorship of no alternatives. There's a very small list of alternative arrangements for the organization of different parts of social life available in the world. And this restricted menu of institutional forms is, as it were, the fate of the contemporary societies. If we are to escape this fate, or at least enlarge it, we can do so only by formulating a different idea of what those structural arrangements can and should be. So the central subject is the subject of the role that thinking about law, legal thought, could play in the transformation of the situation, in the subversion or in the replacement of the dictatorship of no alternatives. One of the intellectual connections, one of the key conceptual links between these two themes, one of the links in the realm of theory, of social theory, is the idea of a regime. That's another word for what I'm calling structure. There's a basic formative institutional and ideological context in every society, a set of decisive institutional arrangements, the way of organizing politics, the state, the way of organizing the economy. And these arrangements shape the surface conflicts and routines of social life, especially the conflicts over the resources by which we collectively create the future within the present. The conflicts over economic capital, political power, and cultural authority. The fact is that we have no widely agreed or even usable idea of regimes. Classical European social theory, especially Marxism, had a theory of regimes, but its assumptions are no longer believed in, even by its own adepts. Contemporary social science has not provided us with an alternative. Legal thought could play a central role in the formulation of an idea of regimes and regime change. And that will be one of our concerns in our discussions in the course of the semester. Now, there is today a hegemonic practice of legal analysis. It is especially headquartered in two countries, in the academies of two countries, in the United States and in Germany. And from those two countries and their academies, it is disseminated, it is propagated throughout the world. It is a conception that law should be interpreted or elaborated purposively the way to understand every piece of law is to attribute a purpose to it, and that these purposes should be expounded, described in the language of impersonal principle and policy, of impersonal principles of right and policies responsive to the collective interest. And this idea, sometimes called reasoned elaboration, reasoned or purposive elaboration of law in the vocabulary of policy and principle, is related to the debate about regimes in the following way. This dominant practice of legal analysis, this retrospective rationalization of law in the language of impersonal policy and principle, is used in effect to make the last institutional settlement, the last institutional and ideological refoundation, appear to be a system. So the last institutional and ideological settlement was the social democratic settlement of the mid-20th century, sometimes also called the mixed economy or the regulated mixed economy. And its counterpart in the United States was Franklin Roosevelt's New Deal. The premise of this dominant practice of legal analysis, the one that understands law purposively and then describes the relevant purpose in the language of policy and principle, is that this settlement can be rationally understood, even though prospectively, before the fact, it may appear to be just the relatively accidental result of a conflict among interests and forces which resulted in a certain social truce. The truce is then mapped, described retrospectively in the language of policy and principle. Retrospectively, we can look back on it and see that it really is a system, and the jurist can describe it systematically in this language of policy and principle. This conception of law, of legal thought, has as one of the props to its self-understanding a certain prejudicial view of its predecessor. It looks back on the legal thought of the 19th century, and it condemns that 19th century form of legal thought as conceptualist, as dogmatic, as superstitious, and it sees itself as liberation. So the idea now in legal culture around the world is that in the 19th century there was something called formalism. There was a deductivist, doctrinalist, dogmatic view of law. And now something else has come, which is this purposive understanding of law, this teleological understanding of law, developed in the language of policy and principle. And it's a liberation from the 19th century conceptualism. It's the wave of the future. Now, I'm never going to conceal my position in these debates, and my position is that this is not the wave of the future, and that the interest of humanity and of all the major nations of the world is to repudiate the supposed wave of the future and to develop another future for legal thought. Of course, in practice, one of the great forces that contributes to the propagation of this idea is mental colonialism. Even when countries may resist colonialism in its explicit form, they may be subject to mental colonialism. The ideas imported from the countries and the cultures that are regarded as the point of reference exercise an enormous influence and authority in the world. The problem is that the cause of strong national projects, national rebellions, widely approved in the world, cannot be separated from rebellion against the dominant ideas. So there's always a contradiction between the force of national resistance to these hegemonic ideas in the world and the willingness to submit, at least implicitly, to the authority of these conceptions imported from abroad. But I'm not claiming that the wave of the future is bad only for the developing countries, for the third world. I'm making a much stronger claim. I'm saying it's bad for everyone. It's bad for the Germans and for the Americans. It's bad for the countries from which it's imported, just as it's bad for everyone else. Although for the rich countries, the resistance to it may seem to be only a luxury, whereas for the other countries, it's a question of national salvation. Now, before I go any further in this discussion, I want to turn the conversation to a subject which may seem strange or irrelevant, but is very significant if we want to understand who are or could be the agents of such a transformation. And the subject is the law schools and the national elites in countries around the world. Now let me describe to you a situation which may not be familiar to everyone. In most countries in the world, not just recently, but for a long time in modern history, the aspirants to inclusion in the national elite go to law school. Of course, one of the reasons why they go to law school is that there are very few plausible alternatives. Because outside of the United States and the United Kingdom, there's really no college system. There's no system of general education at the university level. So you go directly from secondary school, from high school, to professional school. And law school has been typically chosen as where you go to be, if you aspire to be part of the national elite. Now, what do they think when they go to law school? They think that in law school, they will find the method or the language, at least the vocabulary, by which to describe what the deal is in their society. That's what you're supposed to go to law school for in much of the world. But that's not what they find in law school in most of the world. So I say most of the world, say a country like Japan, or my country, Brazil, So in Japan, traditionally, a large part of the national elite was educated in a single institution, the law school of the University of Tokyo. And what do they think they're going to find in these places? They think they're going to find a way. And the vast majority of the graduates of these institutions are not going to go into some legal profession. Narrowly conceived, they're not going to become attorneys and judges and prosecutors and so forth. They're going to become politicians and diplomats and bureaucrats and entrepreneurs. But nevertheless, they go to law school. And what do they find there instead of this discussion of the deal or the method by which to elaborate and apply to it? They find, or at least until recently they have found, the ancient and worldwide practice of legal doctrine. And what is legal doctrine? It is a form of inquiry and of discourse that is very strange by the standards of contemporary natural or social science. So strange that we can't even understand it in the terms of contemporary culture. So you're supposed to be there in order to understand what the deal is, and what are you going to get instead? You're going to get the description of the 22 types of contractual obligations, the 5 possible sources and modes of property, a whole quasi-theological, scholastic taxonomy developed by the methods of legal dogmatics that have prevailed, at least in the civil law tradition now, for something like 2,500 years. And how are we to understand epistemologically or methodologically legal dogmatics? So you could say it's one of the dogmatic disciplines. It's like theology, by contrast to the sociology or anthropology of religion. It's like grammar, by contrast to scientific linguistics. And so the same thing exists in law. Legal dogmatics is not like the sociology or anthropology of law. It's something else. And how are we to understand what it is? So the dogmatic disciplines, first of all, are not clearly separated from their subject matter. They are constitutive of their subject matter. It's not like they're about some subject matter distinct from them. They're like a spider producing a web all the time. The web comes from them. They make the subject matter. So it's not like law is an external phenomenon and the doctrinal reasoning is about this external phenomenon. So this is related to a characteristic confusion that the Anglo-American lawyers have about the civil law, which is, after all, the dominant legal tradition in the world. They think it's code law, that it's legislation. But that's not how the civilians think of the situation. The codes for a civilian are something like the restatements in American law. They're a temporary summary of doctrinal conceptions, which the jurists have developed. So the Napoleonic Code, the paradigmatic civil code in private law, was to a very large extent simply a restatement of the situation of private law as developed by the jurists over centuries at that time. The second characteristic of the dogmatic disciplines is that although they're continuous with their subject matter, the subject matter itself is bifurcated. There's an external level of rules, of standards, of doctrines, and there's something underlying. It's a symbolic form. So there has to be some underlying set of interests or values which are then read as guiding the interpretation of the surface. So it's the engagement with a symbolic reality, which the jurist has to understand the underlying spirit, not just the external rule. The Romans said to understand the law is to understand its spirit, its force, not to follow the words literally. And the third characteristic of the dogmatic disciplines is that they have a normative punch. They're not just a disinterested discourse. They're meant to enlist and impose some kind of authority. So even in grammar, if we compare grammar to linguistics, linguistics is a neutral, agnostic description of linguistic practices. But grammar is supposed to tell you how you should speak, how you should write, what the paradigm of correct usage is. And in all the dogmatic disciplines, we give also the example of theology. Theology is an interested normative discipline which has prescriptive force, which, as I say, is constitutive, at least in part, of its subject matter, and approaches its subject matter as having a symbolic complexity. So, to return then to my subject about the law schools. They go to law school as candidates for inclusion in the national elite, thinking that they'll find there an account or a way, a method, a prestigious language in which to discuss with the other members of the elite what the fundamental arrangements, the deal as I call it, is in their society. And instead they find legal dogmatics. That's what they find. The traditional forms of legal dogmatics were preserved in the world for a very long time. So, for example, when I went to law school in Brazil, I had for 5 years the course in civil law. The same teacher taught us 3 times a week for 5 years, an endless system of categories. It was like a fossilized version of the German doctrinalism called Pandectism of the 19th century. It had already vanished in most of the world in that form. But I was lucky enough to be able to to have the fossilized version before it disappeared completely. And I have to say, I just absolutely loved it. It was like a spell. It was like a fairy tale. A thousand nights retold by the same person. And let me tell you a little bit more. And it went on and on. That was this doctrinalism. So what does this have to do with what the elites do in the management of the state? Very little, apparently. It's like saying the English elites, to manage the empire, went to Oxford and Cambridge. And what did they get there? Did they get ideas about how to manage the empire? No, they got Greek and Latin, the Greek and Latin classics. Now let's take the United States, because the United States is in this story that I'm telling an exception. In the United States, the constituency of the law schools is much, much narrower. A much higher percentage of people go into law school to practice some legal profession. So in a previous generation, they used to ask students who came to Harvard Law School, for example, are you planning to practice law? And a huge percentage of the students would say no. But if you followed them later, you would see that the majority of them would practice law in some form, even though maybe not permanently. They'd then later go on and do something else. But it was a different idea, the idea that this is not just the generic form of inclusion in the elite, although it may be very useful in the United States for elite status. The practical result is the legal profession. Even in the elite American law schools, many of the students are burdened by debt and feel that they have few active professional options. So they go to law school with the idea that it's a way of avoiding a narrow specialization, and then they discover, to their chagrin, that it's not what they thought. Many of them go into these corporate law firms where a very high percentage are absolutely miserable because they've had fancy educations, they've done very well, and they're treated as serfs doing mechanical work. And the atmosphere is not the Emersonian atmosphere of self-reliance and liberation. The atmosphere is the atmosphere of Melville's story of Bartleby the Scrivener. They're hunched over the table doing mechanical work, burdened by these oppressive hierarchies and routines and this low-level mechanical stuff, which is at least giving them the money to pay part of their debts. And now, that's very far from the idea of inclusion in the elites. And the faculties of these law schools have now had a remarkable evolution. So in the course of the 20th century, as a result of successive movements from legal realism to critical legal studies, different forms of legal skepticism, the Americans seem to have concluded that law has no distinctive intellectual content. it was a misreading, a misinterpretation of the message of legal realism and critical legal studies, but it was the conclusion that they derived. And as a result, something has happened in the American Legal Academy which happens nowhere else in the world. The law professors in the United States, in the elite law schools, are expected to have advanced study, even doctoral degrees, PhDs, in non-legal disciplines. In every other country in the world, the law professors are expected to have doctorates in law. Now, on the whole, in the United States, only foreigners seek to have doctorates in law in the United States, because in the rest of the world, law professors are expected to have doctorates in law. In the United States, they're expected to have doctorates in all the other disciplines. And why is that? It's because the Americans concluded that law has no intellectual content. The content, therefore, has to be imported from everywhere else. From economics, from sociology, from philosophy, from political science, from everything but law. So that's a very different situation. So the constituency is much narrower. On the other hand, the curriculum is much more open, because there's no convergence on a narrow doctrinal form. So there's the following paradoxical situation in the world, where the constituency, especially the student constituency of the law schools, is open. The intellectual agenda is narrow. It's this ancient doctrinalism that I described. And where the constituency is narrow, the intellectual agenda is open. So here we are, for example, at this seminar at Harvard Law School, discussing the central issues in social and legal theory. It's an example of the openness, which is very much harder to have in all these other places. Now, I simply make this as an observation, because on this view of the dominant practice of legal analysis, this retrospective rationalization of law in the language of policy and principle, the main subject is adjudication. So what's the perspective of the legal theorist? The legal theorist imagines himself as whispering into the ears of the judge. Now, it's not self-evident that that should be the perspective of legal theory, because what is law? Is law about attorneys and judges or cases? Hegel and the German historicists said law is the institutional form of the life of a people, defined in relation to the understandings of ideals and interests and make sense of it. That's what law is. And what do courts and attorneys and judges have to do with that? That's just a tiny little twist, a fragment of the larger story. But where do we find people who know the details? So the social theorists have some abstract conception of a regime, like Marx. I'll describe the laws of capitalism, or the laws of this, or the laws of that. But who has his hand on the details? The details are the lawyers, the jurists. But they're not talking about regimes and the transformation of regimes. They're talking about their narrow business of adjudication, the professional interpretation of law in an adjudicative or quasi-adjudicative setting. So if we are to mobilize legal thought in the service of some rethinking of the regime, of the structure, where do we go to find the people who will actually do this? Will they just be philosophers and social theorists? It seems that they have to have some intimate understanding of the details. And we would expect to look at the jurists. But what are these jurists in fact doing? And then we confront the question of the law school, the story that I've just told. So my point is that this whole situation is full of paradox and contradiction. There's one aspect which is not surprising at all. If you imagine a transformative task in the world, and then you say, where is the agent to carry out that task? The basic answer is the agent never exists. A transformative task requires an agent, but the agent almost always has to be created later. Because the world, after all, is arranged to reproduce itself and not to transform itself. And it's not surprising then that it doesn't create agents for its own transformation. The little story I told about the law school suggests that you can't understand what goes on or what doesn't go on in the law schools as the imposition of a functional necessity. Where there's a constituency for a broad conception of law, we want to know what the deal is. How do we talk about it? How do we change it? You find this ancient scholastic doctrinalism. Where there's a narrower conception, a narrower constituency, you find an open intellectual agenda. As in the American law schools. Although the professional horizon of the agents is still focused narrowly on their careers and their situation. The agent whom we would need for this exercise doesn't exist. And for the reasons that I've just argued, it's natural that it doesn't exist. It would never exist. The task has to come before the agent. Now, before I go any further, I want to stop and ask for your comments about this initial set of remarks. There's a very practical point which was at the beginning. So, and it's sort of one of the anchors of the discussion. It's the idea of the wave of the future. We know what to do. What to do is to interpret law purposively in the language of impersonal policy and principle. That's the successor to the 19th century conceptualism and deductivism. That's the wave of the future. And that's how we'll practice law all over the world. And the question is whether we should take that to be the wave of the future. It is, what are its defects, to anticipate a discussion we can have later? It wants to see the evolution of legal thought as a progressive approximation to the formulation of a system, a rational system. So there are always going to be some parts that don't fit. But the idea is that the law works itself pure, in Lord Mansfield's phrase. So the teacher says to the students, here's a bunch of cases, they seem to contradict each other. And what are the students supposed to do? They're supposed to expound an underlying logic of policy and principle that makes sense of most of the cases, but not of all of them. Because if it made sense of all of them, it might be taken to make sense of none of them. It can't be a purely elastic structure of justification. It has to make sense of most of them. Some of the cases won't fit, and then you'll say those are the cases that were wrongly decided, and you'll exclude them. That's what's supposed to happen. Now, is that what law is really like? Is it a cumulative approximation to a system? Or is it a set of contradictory ideas in which in each branch of law there's a temporarily dominant solution and a series of deviations or exceptions, of countercurrents? So first of all, you might say this is a mystification of law. Law is not really like that. Now, second, the idea in this retrospective rationalization of law in the language of impersonal policy and principle always requires that you, in the name of improving the law, putting the best face on it, of making it seem not to be just a bunch of accidents and of crude compromises, you improve it. But in the course of improving it, you create power or an opportunity of power for these legal notables who, in the name of improving the law, change it. But the third defect is the fundamental defect. The third defect is the fundamental problem. The fate of society are these regimes, which are described in detail in the materials of law. If we want to criticize and change the regimes, we can't just do it abstractly. We have to go into the details. And the problem is that legal thought then is diverted from this larger responsibility of being the interpretation and the criticism of regimes into this task of casting a retrospective halo of rationalistic justification on the regime, of making it seem to be an approximation to an idealized system. And when does that become important, that defect? It becomes important if we think that the present regime, the present settlement, like the form of social democracy that resulted from the collision of social democracy with neoliberalism, the eviscerated or diminished form, cannot solve the problems of contemporary society. So we need something else. But are we going to get to something else from the people who are worried about courts and cases and attorneys and judges? They're the ones who know the details. Others might be interested in the subject, but they wouldn't have their hands on the technical stuff. Well, let me stop there and say, and ask for your comments or questions. I'm sure that much of this is puzzling. Yes.
So in this conception that you put forward about kind of retrospective rationalization
Yes.
of the situation, can you say more about the underlying conceptions of history that are relied on? So think of history as a measure or a resource or as a horizon never within reach. Like, what are the underlying conceptions that enable that retrospective rationalization?
What are its presuppositions?
Yeah.
What are its conditions? So I think it's very interesting. So you can approach, I can begin to answer your question by saying, look, we have, take the United States, take American political and legal culture. There are two contradictory ideas of law. One idea is the idea formulated in the vocabulary of interest group pluralism, which is there's a conflict between social groups, social classes, with different ideologies and different interests. And so long as all of them play by the constitutional rules, the outcome is acceptable. Now, what then do you expect the law to be? The law is to be an arbitrary set of truce lines or compromises that result from this constitutionally regulated conflict of the interest groups and the classes. But what is the presupposition of the retrospective rationalization of law in the language of policy and principle? It's that the law isn't that. The law is not just this arbitrary, historically located set of compromises. The law is an inchoate system. So the participants in the political conflict from which law results thought that they were really different, thought that they had different ideologies and different programs, and thought that the law that resulted is simply the outcome of a correlation of forces. Some were more powerful than others. The importers were more powerful than the exporters in the design of a particular form of regulation, of economic regulation. And the law that results then is then a snapshot of that correlation of forces. Now, is that the premise of the professional interpretation of law? No. The premise of the professional interpretation of law is that if we then retrospectively look back at the law, we'll see that even though the agents, the political agents, thought that they were radically divided from one another, they were the unwitting instruments of the formulation of this system, which the jurists come after the fact, after the political battle has been interrupted or momentarily stopped, said, this is what you were really doing. And I will expound it in the language of policy and principle. So, in the history of philosophy, we know this is the right-wing Hegelianism. You ask, under what conception would this be true? The real is rational. There's a scheme that's developing, which now the problem is that not only is this seem to be inconsistent with our common understanding of how history happens, but it seems to be incompatible with any strong conception of democracy. The law is supposed to be an instrument of collective self-determination, of popular self-government. And if, in fact, the political agents were the unwitting instruments of this scheme, they weren't aware of it, it was false consciousness. So the problem is there's a prospective genealogy of law, which is law that comes out of conflict before the fact. And then there's this retrospective genealogy, which is the work of the professionals. You look back at the law and you find that unknown to its agents, it was creating this system. How can that be? So that's how I would begin to answer your question. Huh? So there are lots of claims that I made or observations. One of them is about doctrinalism. We're going to come back to them through the discussion of this little text called The Universal History of Law. That's really the source of many of the enigmas of legal theory. So, let's go back to the idea of the Middle Ages. The jurists are the custodians of the basic doctrinal categories. The common law, the jus civile, the common law in the law, not in the Anglo-American sense, but in the civilian sense. And they interpret and elaborate it. That's what the medieval lawyers called the jurisdictio, this custodianship of the common law. The prince then intervenes episodically in this body of law to adapt it to current circumstances or to deal with emergencies. But he's not the author of the common law. The common law is the product of the jurists. Now we have democracy. And the premise is that every part of social life should be the expression of a collective decision, collective self-determination. But what is legislation under the current democracies in fact? In fact, is it not in some sense like this gubernaculum? The prince intervenes episodically. That's the gubernaculum, as opposed to the jurisdictio. The application and elaboration of the common law. So, is there not a real structure of social life that is for the most part left untouched, unrevised, even unseen? And then the statutory legislation comes in and it takes a little part of it and changes it, like the prince was doing. That's not what's supposed to be. It was the law is supposed to be the choice of the terms of social life by everyone under democracy. But because they're weak democracies, that's what the law really means. So there's a real structure. So then we have three elements in law. We have the real structure, which in practice is changed only marginally and episodically outside of a revolutionary situation. Then we have the statutory law, which are these episodic interventions by the prince, including the democratic prince, the democracy. And then we have the jurists, reproducing the received body of law from one generation to the other in these categories of doctrine. What do you think about my story, my narrative regarding the law schools? Yes.
I think it was spot on, at least in my experience. I'm a 3L here, and I've committed to go do private equity stuff at a big law firm. But I'm in this class. I'm in your other American democracy class. I'm interested in political economy, and I ideology and international relations and
Uh-huh.
power relations, and yet I'm gonna go look at contracts and run diligence. And part of it's due to this sort of, you know, their creation of a structural incentive debt to go sell my labor on the market, right?
Uh-huh.
And I mean, the story, I think, I found myself nodding along with, like, in agreement, just as a reflection of my individual experience at a school like this.
You found yourself disagreeing?
No, agreeing,
Agreeing.
yes.
Uh-huh.
Yes,
What- what-
I spent 5 years in a European law school listening to the spells and the fairy tales, and I was just always missing this, looking beyond the law, behind it, ideology, politics.
Uh-huh.
This is why I also came here. So now I was just thinking, is the only problem that should we export American-style law schools and make them publicly available to people so they don't need to go into debt? And is
No,
this
I didn't follow you. What are you suggesting?
So I was wondering, so you said either everybody goes to law school to enter the elite and then learn nothing, or only a subset of people go to the law school and learn the secrets of power and how to change society, but then cannot go change it because they have debt or structural incentives to go to the judiciary and not change it. So I was thinking, is the only problem that we should expand the constituency and
Well, let me make explicit the premise, which maybe it was not fully revealed in my discourse just now. So I think that there are two different missions of legal thought. There's a narrower mission and there's a larger mission. So the narrower mission is the traditional vocation of legal thought, which is to deal with the vindication, the defense of rights, the resolution of disputes in an adjudicative or quasi-adjudicative setting. The larger vocation of law is to be the way of thinking about a regime and its transformation. And the addressee then is not the judge. The addressee are the people, the citizens. But of course, this larger conception, however attractive it may appear in the abstract, has no practical expression because the way of doing this is not apparent. Who's going to do this? In which the jurist becomes a technical assistant, not to the judge, but to the citizens, to the people. There's no intermediate link. There's no set of links that enacts that as in a practical form. So this dominant form of legal analysis, which is now exported around the world as the providential alternative to what came before. What came before was supposedly this deductivism or conceptualism, cast this halo of rationalizing justification on the current regime. And what is the current regime? How are we to understand it? So in the mid-20th century, there was this settlement, social democracy, this social democratic compromise. It says, it was an expression of this hydraulic model of ideological controversy. Market and state. More market, less state. More state, less market. compromise between market and state, that's social democracy. And social democracy had a series of particular features, which I'm not going to discuss now. Among them, the protection for insiders against outsiders. For example, relatively stable and tenured workers against precarious employment workers. Or small business against big business. Or incumbents against challengers in the market for corporate control. Social democracy, historical social democracy, then collided with neoliberalism in the late 20th century. Neoliberalism criticized the social democratic measures as being both costly and unjust. They were costly because they imposed a series of economic rigidities that would diminish the growth of output and the enhancement of productivity. And they were unjust because they defended insiders against outsiders. So from the collision of neoliberalism with historical social democracy, there resulted what we could call social liberalism, the flexibilized or liberalized version of social democracy. Which, for example, I'll give you a concrete example of a typical tenet of social liberalism. Typical tenet of social liberalism is the so-called flex security. Okay? The workers should enjoy protections, but the protection shouldn't be narrowly dependent on the possession of a particular job. So the protection should be separate from the job, universally portable, so that we can have economic flexibility and social protection in some form at the same time. That would be social liberalism. Now, if you radicalize this idea, if you generalize it beyond the narrow example that I gave of the labor market, it's a very general idea with a great potential. And you could describe it in another vocabulary, which is the following. You could say, historical social democracy is overwhelmingly concerned with the protection of the individual citizen and worker against, especially against economic insecurity, against the ravages of the market. So it wants to give the individual worker and citizen a haven to safeguard him against this radical economic insecurity. But what it doesn't do is to arouse a storm of innovation and experimentation in society. It has a discourse about the haven, but it doesn't have a discourse about the storm. The issue which under flex security is narrowly characterized as just about the labor market is a very general issue of social design, in which you could say, what we want is both. We want there to be a haven, but we want to arouse a storm of innovation and experiment in society. The storm doesn't occur spontaneously. The storm has to be arranged. And that would then lead to a different set of institutional arrangements. Social liberalism in its current form is an accidental set of compromises, a partial evisceration of the historical content of social democracy. Then come the jurists, and they pretend, as it were, that this accidental compromise is a system which can be expounded in the language of policy and principle. And they cast on it this halo this, this, this reflexive halo of rationality and authority? Is it in our interest that it have this halo? Or is our interest precisely to emphasize the opposite? That it's full of contradictions. They can develop in different directions. There has a potential for this or for that. And the potential can only be realized through the institutional details. And therefore, what is the interest for society of the work of the jurists? It's to take the little variations and contradictions that exist in the present law and the present practice as a prefigurement of much larger alternatives that might be created. And that then leads to the resistance against the wave of the future. Because the interest of the wave of the future is to pretend that it's all rational. It didn't seem rational before the fact. Before the fact, it seemed to be just a bunch of conflicts and compromises. But after the fact, the jurist comes and says, no, you thought you were at battle, but we, the heroes who have been following the battle, understand the underlying logic, which we can expound retrospectively in the language of policy and principle. Is that an achievement or a failure? Yes.
Maybe this doesn't get exactly to your question, but in terms of my reaction to your discussion of law school, I definitely resonate with what the others said. And also, I thought I would come out of law school with a way to apply the law to facts, like practical skills. And I feel like it's kind of challenging when you can rationalize things in the past, but if you have clients as a lawyer or just thinking about a person operating in society, how do you sort of have a forward-looking view of the law to know if your behavior is kind of regulated in a system that seems like it only makes sense in hindsight, if that makes sense?
I'm not sure. So what's the question that you're posing?
I guess it's not really, I thought the question you asked was, is this a good thing that we implement a system that...
Yeah, is this retrospective rationalization a good thing or a bad thing? So the reason why the jurists who are the ideologists or the propagandists of this wave of the future think that it might be good is, one of the reasons is the following. They say, in the real society, there are certain groups that are underrepresented in the making of the law. And by putting the best face on the law, we will make the law more beneficial to the people who are least represented in its making. So we come after the fact and we interpret or reinterpret the law in the light of these policies responsive to the collective interest or these impersonal principles of right. And who is going to benefit? The groups that are most likely to have lost out in the politics that made the law. That's their argument. That by this idealization of law, they improve the law in the course of interpreting it. And their wards, so to speak, are the poor, the minorities, and so forth. The vulnerable. That's the argument. But at the cost of this mystification and this substitutionism, in the sense that the legal notables take the place of the people, take them by the hand and say, this is the road. And maybe what we need is conflict and not custodianship. It's a different idea. Yes?
Yeah, in the context of what you said about the jurists being like the author of the law and the prince only intervening occasionally, I was thinking in the context of, for example, British colonialism in India. I'm
Yes.
from India. I've always found it interesting how, like in the 19th century, when the British in England still had the common law and didn't legislate too much. At the same time, in the colony in India, the prince was making laws, like very detailed codes on criminal law, criminal procedure, etc. At the same time, when they had a different system back home. So I'm almost wondering that about just the last thing that you said, that if the justification of the jurist for the jurist's retrospective genealogy is that it's like a benevolent idea that we will sort of present the best face of the law for the people who are not involved. In this dichotomy between what the colonialists were doing in the colonies versus at home, I think you are right, because over here you can see that that concern is not there. Like, I don't think they retrospectively justified a similar idea of the common law in like India. Instead, they just created it prospectively.
Yes.
So I think that shows this kind of contradiction between
Yes.
how we were doing it.
Yes. Now, someone here wanted, yes.
The problem you just mentioned in the end, the relationship between the people and the jurists, and how you want to avoid the jurists being the custodians of the people, which I think is kind of like the problem of the 20th century. How do you think that there can be a different relationship between the legal elite and the people in such a way that the legal elite do not substitute?
I can only answer this question by going into a particular domain, right? Because I think that the comparative advantage of law and legal discourse is to deal with the question of regimes or institutions at the level of detail. The jurists, if they're specialists in anything, they're specialists about the institutional detail. So let me give you now a series of examples in the field of the institutional arrangements of democracy, which, after all, that's one of the most important things if we're talking about the people and versus custodianship of the people. So there are a series of dilemmas that haunt practical politics and political theory in the design of constitutions. So one dilemma is, in the organization of a democracy, you must, at the end of the day, make a choice between Madison and Mussolini. In other words, either you have a politics that is cold and institutional, that would be Madison, or you have a politics that is hot and anti or extra institutional, that's Mussolini, that's Caesarism. Now, and that then seems to be an insuperable dilemma. Now, is that true? So you have to have a view of what the transformative alternatives would be, what the possibilities are. And you might say, politics can be both hot and institutional. This premise of conservative statecraft is false. It can be both hot and institutional. It depends on the details, the rules governing the relation between politics and money, between politics and media, the means of mass communication, the rules of voting. For example, should the vote be mandatory, as it is in many democracies around the world? The vote is mandatory. And so small institutional changes can have big institutional effects. And on this question of elevating the temperature of politics, which is the degree of organized popular engagement in political life, because you could say a politics rich in structural content, a politics with the attribute of structural fecundity, is necessarily a high energy politics, a high temperature politics. Now take a second example. A second premise, which is manifest in the design of the American constitutional arrangements, is take the liberal principle of the fragmentation of power in the state. There should be many sources of power. The conservative principle is the slowing down of politics, as in Madison's scheme of checks and balances. The bias of the Madisonian scheme is to inhibit the transformative uses of political power by perpetuating impasse. So there's an impasse, for example, between the Congress and the president, and you will, instead of resolving it quickly, in the spirit of Popper's comment about science, the point in science is to make mistakes as quickly as possible. Say the same thing in democratic politics. Make mistakes as quickly as possible, resolve them. So you could say, we will have a system that will allow each of the two political powers, the president and the Congress, to resolve the impasse by calling anticipated elections, provided that the power that exercises the constitutional prerogative to call the early elections has to pay the political price of running the electoral risk. So the elections will always be bilateral for both branches, but even though only one branch exercises the prerogative of calling them. By that simple device, you could change the logic of the presidential regime. Instead of being a machine for the slowing down of politics, it would become a machine for the acceleration of politics. Now take a third domain, the relation between the initiatives of the central government and the powers of parts of the country in a federal system. You could say, the conservative view is that there's a pendular relation. Either the center has power or the periphery has power. But you could say, in opposition to this, that depending on how you shape the coexistence of concurrent and divided powers within the federation, you can have more of both. You can say the central government should have the power for very strong initiative, but under certain conditions, part of the country should be able to secede from the general solutions, the predominant solutions, and to create a counter model of the national future, taking seriously the idea that federalism is to have laboratories of experimentation. Of course, the exercise of this experimental divergence would have to be vetted, both politically and judicially, to prevent it becoming a device for persecution or class privilege or racial oppression or whatever, as happened in the history of the United States. This is the problem of states' rights. So you could go down the whole list, and little by little, the whole shape and effect of democratic life would be changed through an accumulation of details, not through the spectacular substitution of one large regime, capitalism, by another, socialism, but by the real form of structural change, which is fragmentary, which is little by little. And so that's then the discussion. So imagine that little discussion, which I've just suggested to you, in the constitutional domain, expanded to every part of social life. All of social life is like that. Our ideals and our interests are nailed to the cross of the institutional arrangements that represent them. So why should we allow them to remain crucified in this way? Let's change their institutional form, and let's change them piece by piece and part by part. That then would be the fundamental reason to resist what I call the wave of the future. Because the wave of the future is preventing us from doing exactly that. The wave of the future is preventing us from, through the the discussion and the transformation of the details changing the fate of the society.
But don't you think that like the slogan focusing on the detail and kind of like more partial and situated interventions and changes, the problem with that, it's really difficult to translate that into a political program. A political program requires a level of unification in order to build a coalition around it.
It requires a general view.
And, yes,
A
but-
general view, but there would be a general view. So for example, take that vocabulary that I used earlier in today's class about the haven and the storm. So that's a general view. It's saying we want a society that enhances the experimentalist agency of all of its citizens, that allows them to be creators, to be innovators, not just to be beneficiaries. Historical social democracy pays everyone off. Everyone becomes a kind of rentier, a social rentier, rather than an entrepreneurial rentier. And we create this haven against the market. But we don't want just that. We want this storm of innovation. We have now in the world a new economic productive vanguard, the knowledge economy, but it exists only in an insular form, in these little fringes. The vast majority of workers and firms are excluded from it. We want to create a knowledge economy for the many. So this, as I said before, the storm of inclusive innovation and vanguardism doesn't occur spontaneously. It has to be arranged through the creation of a high-energy democracy, as by the constitutional examples I just gave, through the democratization of the market order. And those aren't just abstract slogans. Those turn on these institutional details. But the details can be brought under the aegis, under the heading of these large ideological projects, which then become the programs of political parties. Yes?
Yeah, so part of the very broad intellectual history question, but I'm wondering if your critique applies primarily or only to 20th century regime settlements like social democracy or neoliberalism or whatever, or to liberalism to core in all its forms since the 18th century, classical and progressive and so on. What I mean by that is that, like, when I think about points of your critique, we talk about like proceduralization, like the idea that you're domesticating political conflict into a game, a technocratic game for specialists without spirit, like jurists. You talk about like, the curtailing of the law, the democratic act of self-determination. I feel like right-wing critics of liberalism like Schmitt and left-wing critics of liberalism like Foucault would agree with you and say that that's true of kind of all forms of liberalism since the 18th century. And similarly, the kind of
That what's true of all forms of liberalism?
these points of critique, so curtailment of the laws of democratic act of self-determination, domestication of political conflict, proceduralization, the kind of Madison-Mussolini dichotomy that gives a conservative bias and kind of anti-democratic suspicion.
No.
It seems like most of these points would apply in the partner's education.
Well, I think the problem is, first of all, the problem is that liberalism is not the description of a social reality, of a form. Liberalism is a theory. It's a theoretical approach to social life. One of its crucial tenets is that is the separation between the sectarian good and the neutral right. So the object in liberalism is to establish, and in order to establish, to imagine a system of rights that is neutral among sectarian visions of the human good, so that people with different conceptions of salvation and happiness and the good can live peacefully together. And so the objections to it can't be just practical objections. The objections to it have to begin with the theory. And I would say It's false. There can't be a neutral framework of rights because every institutional framework of social life tilts the scales in favor of some forms of experience and against others. So the idea of neutrality, which is central to liberalism as a theory, is not only false but dangerous, because in practice, every claim that a system of rights is neutral will be adduced in favor of the opposite. That is, as a way of entrenching a particular vision of the good against others. Nevertheless, and here the discussion becomes more interesting. Nevertheless, the false liberal idea of neutrality has a kinship to another idea which is valid and in fact indispensable. Every form of social life should be open to a wide range of contradictory experience. And the institutions of society should have the attribute of being revisionist, of self-revision. That is, they should help organize and nourish their own transformation. So better than the notion of finding the neutral framework is the notion of finding a framework that facilitates its own correction. And then corrigibility and contradiction become the legitimate successors to the false liberal idea of neutrality. So that would be a way of engaging liberalism on its own ground, of being a theory, but with propositions that have a host of practical implications. So we were just discussing now some of the constitutional arrangements that might, in fact, enact this experimentalism. Yes?
Does that neutrality characteristic of liberalism, the false neutrality, do you interpret that as also related and part of sort of a reason-focused legal theory that is, again, as you said, retrospectively rationalizing everything in impersonal language? There is this air in sort of that rationalization that this is totally neutral.
Yes, of course. Yeah. So this wave of the future, this policy and principle form of legal reasoning, thinks of itself, among other things, as the instrument, the vehicle of neutrality.
Can I ask, from that place, how do we reconcile that with some, like, we all implicitly know that the law has some normative, like, goal, right? Like, it has some principal object, or we rationalize it to make it so. That normative object isn't, I don't know how, I mean, I guess, do we contort that to also be neutral?
Not neutral in the sense of liberal theory. Neutrality for liberalism means neutrality among conflicting visions of the good, or conflicting visions of salvation. And that's a false idea. There's no system that's neutral among those things. But nevertheless, as I say, there's a legitimate substitute for neutrality, which is a lot of contradiction, a lot of conflict, a lot of corrigibility. That's what we want. We don't need to find the perpetual motion machine. We need to find a way to keep changing. So it's perpetual disruption, in which we can be the masters of the experience rather than the idea that we're finally home. So of course the philosophical premise is that we're never home in history, that the human spirit has no institutional home. But nevertheless, some institutional arrangements are better than others, because some empower us more than others and allow us to be the masters.
Yeah, it just brings to mind sort of transition
Yes.
between like contemporaneous consent and continued, like common law, you're finding the law, it's changing, you're clarifying it, and then this need for fixity, for like a fixed sound structure to everything. And I'm not trying to resolve it, but it speaks to, it just makes.
Well, I don't believe in fixity, as my, should become evident. So I think we need a replacement for fixity, just as we need a replacement for neutrality. Yes.
But how can you also, like, the idea of perpetual conflict and perpetual change, sometimes this could also serve a neoliberal paradigm, in the sense of it could be, for example, the marketplace of ideas.
Well, no, it doesn't.
Creative destruction.
No, so the neoliberal idea, part of the neoliberal idea is that the market as a spontaneous system of coordination has its own logic. And I just said in another course, I said, this is the idea of market fundamentalism. If Robinson Crusoe trades on his island long enough, he will eventually reproduce the whole system of German private law. In other words, that built into the idea of spontaneous economic coordination and exchange among free and equal economic agents is a particular institutional logic. And all we have to do is to prevent the state from intervening it and let Robinson Crusoe continue to do his magic. And it's always going to have the same result. That's false. The jurists know it's false. That was the most important achievement of legal analysis in the 150 years from 1850 to the end of the 20th century. That is, the jurists, including the conservative jurists, set out to demonstrate that the market economy has an inherent institutional order. And they ended up demonstrating the opposite. And the way in which it happened was, so you take an abstract conception like private property or freedom of contract, and you begin to concretize it. And what jurists like Oliver Wendell Holmes, who was no radical, demonstrated was that as you go down the ladder, you have choices to make. And you can't resolve these choices by inference from the initial abstract conception. That is, if, for example, you have a choice between one or another version of how to manage relations among neighboring farmers in the control of water and access to water, you can't infer the answer from the analysis of the abstract idea of property or freedom of contract. There's a concrete conflict of interest and vision. And the detailed form of the market that emerges is the one that results from all of the particular responses to these concrete conflicts. That's what they demonstrated. And it's totally against this notion of the market fundamentalism. Robinson Crusoe there would never be a convergence to German private law arising magically or spontaneously from this exercise. Yes?
Yeah, so you mentioned earlier that one of the elements in the law is that the real structural change of law happens only in the revolutionary settings. So I'm wondering, like, if the institutions are basically self-revisioning, can that achieve like real structural change in law?
Can that achieve what?
Real structural change in law.
Well, I'm making a stronger claim. I'm saying that's the only way that structural change can only happen in fragmentary form. That's the only real form of structural change. In other words, the idea that the characteristic form of structural change is the substitution of one indivisible system by another capitalism by socialism and so forth, is a fantasy. So it's systemic change is the idealized limiting case of real structural change. And real structural change is always piecemeal. And every partial change can be either a step towards another change, that is, in real historical experience, the meaning of every initiative, like every political initiative, depends on what comes next. Or it can be a way of avoiding the next step. It always has this ambiguity. But that's how it is. That's the only way in which we have structural change. Now, if we think that structural change is by its nature fragmentary and always has built into it this ambivalence, where do we find it in its fragmentary form? We find it in its fragmentary form in law. That's where it takes concrete form. The details are only in law, manifest in law. The institutional arrangements in relation to the understandings of interest and of ideals. But then we find that the jurists are concerned with something else. The jurists are not concerned with this. The jurists are concerned with the question, how should the judge decide the next case? And which is, from the standpoint of this larger agenda, like a little twist. It's entirely marginal, it's trivial compared to this. This is the real subject. But for this subject, the agents don't exist, or they're not apparent. Who's going to do it? That was the conversation that we were having. It would be necessary to be a technician and a visionary, a technician and a prophet at the same time. And the world does not provide that, or at least the world does not facilitate that. So I'm just doubling the bet as the conversation goes along. Yes?
How would you comment on the political process here? How would that come in relation to your argument?
How so? What question are you asking?
Yeah, so I was thinking while you were talking that we should leave everything open for revision. So does this mean that lawyers and judges should take a more deferential role and just intervene in disputes to ensure that people can democratically decide?
Well, lawyers, more deferential to whom?
To the people.
Well, I mean, there's something, one of the strange things in the evolution of American thought is that in the United States, the leftists, the radicals, became friendly to the idea of indeterminacy. That given any legal text or legal rule, you can make it mean whatever you want it to mean. Like a Derrida type idea of legal hermeneutics. This is the exact opposite of what the legal radicals always believed earlier and what they continue to believe in most of the world. The prejudice of the legal radicals, of the leftists in law, is the judges have to be bound hand and foot. Because who are the judges? They're notables, they're members of the elite, they're enemies of the popular interest. Why should they have any power? Completely different idea. And I don't think you can understand this evolution in the United States without taking into account the political reality. You were asking about the real political process. So what happened in the United States is that the legal radicals saw themselves as politically marginal. So they could never imagine themselves as sitting in the seats of power. And therefore, what was the best? What was the best is to say, was to pretend it doesn't matter who wins and who loses in politics. Because once the law comes into our hands, the hands of the legal interpreters, the judges, or the faux judges, the people who write law review articles, we can make it mean whatever we want it to mean. That's what they thought. And it's a kind of joke. It doesn't matter who wins and who loses. It has fateful consequences. So this was a fundamental misreading of the relation between law and politics. Now, before we end today's meeting, it's too late now. I wanted to go over this chart, but it's too late. I can't force it into this. So this chart is, I'll do this at the beginning of our next class, is a comparison of the way the 20th century legal thought understands itself and understands law with how the 20th century sees the 19th century. So let me focus on just one aspect. So look there at the conception of law. So the prejudice of the wave of the future of this contemporary jurisprudence is that 19th century legal thought was the victim of a primitive form of conceptualism or deductivism. It thought the law's a gapless system of rules, and from these rules you can infer by a quasi-deductive method of inference the right solution to every legal problem. That's how the adepts of the wave of the future want to characterize 19th century legal thought. That's not what 19th century legal thought was like. It comes much closer to the truth to say that 19th century legal thought had a typological idea of law. That is, there are types of society, of social and economic organization, and each type has built into it a logic, so an institutional logic. So the scheme of order, liberty, the market order is one of these types. So we unpack the type like we unpack a package, and it comes with a content. The content is the whole system of this market order, which is predetermined. Now that's the conservative version of the idea, but I want to point out to you, that was also the essence of Karl Marx's idea of the regime of emotive production. So a society becomes capitalist, it has capitalism. Capitalism comes equipped with the whole content. You open the package, everything is there already. All the basic rules, the legal architecture. That's the real idea. And the method is not so much a quasi-deductive method as it is a method that the medieval philosophers, the scholastics, described as determination or concretization. You take an abstract idea, like freedom of contract or property, and you render it cumulatively more concrete through this method of concretization. And that was a notion. It's a typological notion. Every regime comes with its built-in content. The work of the jurist is to receive the package, open it up, and reveal the content. The prince, the ruler, can't do that. They know what the content is. And of course, this idea is an enormous threat to democracy. Because what is democracy if not the creation of this content? If the package already comes with the content, then the role of democracy is simply at best to choose which type of society do you want to be. there's a small menu of types. One of these types is democratic capitalism. And democratic capitalism comes with a whole apparatus built into it, which the jurists and the economists are going to reveal. So there's no democratic experimentation with the design of this type. So then the 20th century conception, this wave of the future, this rationalistic, retrospective interpretation of law, sees itself as being a break with what was supposed to be the dogmatic, deductivist conceptualism of the 19th century. In fact, it's much more like just a looser, more diffuse version of the same thing, because it goes back to the arrangements, to these compromises, to these truth lines, and it casts this retrospective halo of rationalization on them. It doesn't affirm the typological idea in its heroic, strict form, but it seems to be committed to a looser version of the same idea by making it seem it's not like just a bunch of random compromises. That's what it looks like prospectively from the standpoint of politics. But retrospectively, in the calm of the judicial chamber or the professorial office, it looks like a flawed, fallible, but successive approximation to a system. And we'll tell you what the system is. That's the whole object of this legal science. So I'm going to want to